Good afternoon, everybody. On behalf of the Addictions team and the Division of Mental Health, Developmental Disabilities, and Substance Use Services, I'm pleased to welcome all of you to this training today on 42 CFR, the Federal Confidentiality Regulations. We were pretty astonished and amazed at the number of participants that registered for the training, so we really appreciate your interest. It's a critically important topic, and so we're really glad you're here with us today. I also want to thank Alex and Anthony and the Governor's Institute staff for providing the platform and the logistics for the training, and especially for their ability to adapt and accommodate as the number of participants continue to grow over the last week or so. And now it is my distinct pleasure to introduce our trainer today, Mark Botts, graduated magna cum laude from the University of Michigan Law School. He's been an associate professor of public law and government at the School of Government at UNC-Chapel Hill since 1999. He teaches and provides training on many topics, including the federal confidentiality regulations, Hipaa, involuntary commitment laws, lots of different topics, but just to mention a few. So we truly consider him our go-to expert on 42 CFR, the federal confidentiality regulations. As you can see, specific to substance use disorder regulations. I'm really appreciative of his work and willingness to be here today to talk with us about this. So without anything else, I'm going to turn it over to Mark. Mark?
Good. Can you hear me okay?
Sound good. Thank you.
And then also I'm trying to start my video, but it said the host was waiting. Okay, there we go. All right. Welcome, everyone. So I assume that Dee Dee or Alex, the people who have helped organize this on behalf of the Department of Health and Human Services and the Governor's Institute, will let me know if they have any problems hearing me or seeing the slides.
It all looks great, Mark.
Okay, thank you very much. All right. Today's program is going to be on the confidentiality of substance use disorder treatment records. This program will run from now approximately 12:30 to 3:30. It's a 3-hour program. We'll take a break at 2 p.m. for about 10 minutes. Okay. So let me see here. Let me advance, see if I can advance slides. So the target audience for today, well, the program for today is going to be a comprehensive overview and an update for substance use disorder treatment programs and those who receive information from SUD programs. Okay, both programs and the folks who receive information and therefore have obligations with respect to the information. The questions we're going to answer today are: who must comply with the law? What information is protected? And if you must comply, and if you have such information, when is disclosure permitted or required by the federal law? And then also, while I'm going through this overview and update, I will tell you how the law has recently changed. Now, I would like to get a poll right now of those. Hold on a second. You guys, which slide are you seeing? Dee Dee or Alex?
I see it says applicable.
Okay, so, and then now you're seeing terminology?
Yes.
Well, yeah.
Okay, it's weird because the title's, okay. And then now you're seeing a title of a blank slide that says recent changes?
No, now I see terminology.
Now
you see coronavirus aid relief?
Yes.
Correct.
Okay. All right, okay. I just want to make sure. I've got 3 different slides showing. I just want to make sure that I'm syncing the slides with what I'm saying. Okay, so now we're on the target audience slide, right? Could you put up the poll, Alex, to
Sure.
ask people? I want to get a sense of who's in attendance. And if you could say whether or not you're from one of these agencies or you're one of these kinds of people, if you're this person or representing this entity, if you could please choose one of these and submit your answer. I don't know that we have an other on there. So anyway, just choose the one that fits you best. I would like to get a sense of who's in the program. So Alex, are there any responses coming in, or do we wait to see the responses?
Yes, there about 50% is substance use treatment programs. We have
Is there a way for me to see that?
Sure. Yeah, answers are still coming in, but I'll go
Okay.
ahead and.
Okay, so you want to wait till the answers come in and then you'll show me. I didn't know if I'm supposed to be able to see it in real time.
You should be. So I'm going to go ahead and end the poll, and then now you can see.
I cannot see the poll.
I can let you know. So there's we still are about 50% for the substance use treatment program, about 27%, or no, 24% for public health, primary care, state agency, about 11%, managed care organization, about 13%, and then other is about 14%.
Okay. Any DSS or criminal justice? Okay, now I can see the response. Great. Okay, so very few DSS or criminal justice. Just looking here, state agency. Okay. That gives me a good sense of who's in attendance. Let me scroll down and see. Okay. All right. That's good. So one of the things I want to say to people attending the program right now is that this program is going to be primarily for SUD programs and those on the local government or community level who receive information from an SUD program. I will not go into very much topics that might be interested to MCOs and state agency folks, like audit and evaluation, healthcare monitoring and oversight. That's kind of with what I have to cover today, I won't say much about that. And if folks from MCOs, health plans, and state agency want a program on audit and evaluations, healthcare and monitoring, oversight kinds of sharing and disclosures, then we can do a separate program on that. This is going to be about SUD programs, sharing information with public health, primary care providers, DSS, criminal justice system folks, and how to share that information using either tools, either provisions in the law that allow information sharing, or patient authorization or court orders. That's what I'm going to cover today, along with updates, relevant updates. Okay. So I just want to confirm, you now see a slide that says applicable confidentiality laws, correct?
Correct.
Okay. Just want to make sure I'm looking at the applicable one of three screens, three slides here. I have three different ones showing. Okay, so one thing to keep in mind is SUD service providers are governed not only by the federal law governing substance abuse programs, Title 42 of the Code of Federal Regulations, Part 2, but they're also governed by a state law that governs mental health, intellectual and developmental disabilities, and SUD providers. That law is at General Statutes, Chapter 122C. And these folks, most likely, almost all of them, if they transmit information electronically for any purpose, are governed by the HIPAA privacy rule, which governs all healthcare providers. So there are times when, although this program is on 42 CFR Part 2, I will need to weave in a little bit of state law and a little bit of HIPAA privacy law, because both of those pertain to the topic at hand. Now, when I talk about these laws and the things that the laws talk about, it's important to keep in mind that these three laws are not consistent across the board in the terminology they use. For example, the state law governing MHIDD, SUD service information refers to clients and client information, whereas the HIPAA privacy rule calls the patient an individual. The SUD law calls the patient a patient. So there are times when you might see me use the word patient when I'm talking about 42 CFR Part 2, but I might use the word individual instead of patient when I'm talking about the HIPAA privacy rule. Notice the term under state MH law, facility. Facility is kind of a little bit odd, awkward term perhaps, but that refers to the professionals and the entities that are covered by the state confidentiality law. So any sole practice psychologist and any LME-MCO and any contracted provider with an LME-MCO, a public mental health authority, any agency that provides MHIDD, SUD services that primarily provides those services, or any person that provides those services, such as a professional, mental health professional, they're all called facility, as that term is used in the state confidentiality law. In contrast, HIPAA uses the term covered entity. The SUD law calls the folks, the entities and people covered by that law, Part 2 programs or programs. Now, there have been two recent changes to the SUD law. One is legislation enacted by Congress, and the other is a set of regulations or rules that are issued to implement the current statute. So the Coronavirus Aid, Relief, and Economic Security Act, what we call the CARES Act, and many of you know about this, it was enacted last spring. You know about it because of COVID. However, there was a particular section, section 3221, which amended the statute that governs SUD program records. Although that statute was enacted almost a year ago, the executive branch of the federal government has not yet issued implementing regulations. So the statute is not yet effective pursuant to regulations enacted by the executive branch to implement the changes in the statute. I'm going to tell you about the CARES Act changes, but even though that legislation has been enacted, the changes are forthcoming. By contrast, there was a final rule issued that was already in the works before the CARES Act was enacted last spring, a set of changes to the regulations implementing the standing statute on the confidentiality of SUD records. That set of regulations and changes had been proposed before the CARES Act and then were finalized after the CARES Act. And this is called the August 2020 rule, or the final 2020 rule, because it was enacted in August. It does not include changes as a consequence of the CARES Act. But these regulations, the changes to the regulations in the August 2020 rule, are effective now. So the outline for today is I'm going to talk about the CARES Act first, what Congress did and why. And these are going to be pending changes that will come that are not yet in the regulations, not yet effective. Then I will talk about 42 CFR Part 2 and the 2020 final rule. Now, I'm not just going to talk about changes to 42 CFR Part 2, which is the regulation. I'm going to give you a fairly comprehensive overview of the regulation. And as I go through that, I will tell you how it's changed, but I will also talk generally how it applies to SUD programs, those that receive information from SUD programs that are called lawful holders. I will talk about the basic duty of those two groups of entities. And then I will talk about disclosures required by law with patient authorization or by court order, which are the three primary ways that information could be shared between programs and lawful holders and others. At the end of this program, there's this PowerPoint presentation, which I don't know if is this presentation going to be sent out? Is the PowerPoint going to be provided, Dee Dee or Alex, to folks at some point?
Yes.
Okay, so at the end of the PowerPoint file, there's some additional miscellaneous 2020 rule changes, which we may or may not have time to get to. I'm going to cover everything before that. If we have time, we'll get to some miscellaneous rule changes. If we don't, the slides are pretty self-explanatory, I think. Okay, the CARES Act. Whoops. So the CARES Act, the section that applies to what we're talking about today, revises the regulation, which was implemented long ago to bring into effect the legislation that was passed in the 1970s, making alcohol and drug abuse records confidential. The federal statute is rarely amended and changed. So this was a big deal that Congress decided to make some changes. And Congress directs the Secretary of USDHHS to revise the regulations implementing the act, as well as revise the Hipaa privacy regulations governing notice of privacy practices to include Part 2 programs. Something that the CARES Act does is it adopts some of the Hipaa privacy rule perspective with respect to SUD records, and it references the Hipaa privacy rule, and it pulls in some parts of the Hipaa privacy rule to apply to SUD programs. Again, it's not yet effective, and in fact, the Act said that it cannot be implemented and enforced before March 27th, 2021, and I have not seen any rules issued yet. So keep in mind, any CARES Act changes discussed here are forthcoming and not current law. Why did Congress, which rarely does so, decide to step in and amend the statute governing SUD records? Well, because we have moved with time to a more electronic and integrated healthcare system, there's been pressure to enhance the interoperability of the healthcare system, of all the parts of the healthcare system. So there's been more weight and more desire to accommodate what folks call the interoperability of various parts of the healthcare system. Now, that means allowing information exchange where it wasn't previously allowed. And because the SUD Programs Records Act, because 42 CFR Part 2 and the legislation behind it was enacted with the acknowledgement that SUD treatment information is particularly sensitive information, Congress also said, well, if we're going to enhance operability, we must also try to minimize the risk of disclosure. So what you see is that the CARES Act provisions can be separated into two types. One is those provisions that address enhancing operability, and as a balance, are provisions speak to managing the risk of disclosure or disclosure risk. And again, Dee and Alex, we are looking at the slide that says the CARES Act key provisions, right? And you see 2 columns.
Correct.
Okay, good. All right, so in the area of enhancing interoperability, Congress spoke to the use of consent to disclose information for treatment, payment, and healthcare operations. It also addressed sharing information with prescription drug monitoring programs. I will talk about those 2 things. On the other side, what Congress said, and again, these are coming changes in terms of when they're effective, they beefed up the enforcement provisions. They make the breach notification rules of the Hipaa privacy rule applicable to SUD treatment providers. They strengthen anti-discrimination provisions. They make more restrictions about using information in criminal, civil, and administrative proceedings. And they require a change. They require SUD programs to use a notice of privacy practices that is similar to the notice of privacy practices used by covered entities with patients under the Hipaa privacy rule. So one thing I want to do, we need to set the context here. I said I would mention the Hipaa privacy rule while talking about 42 CFR Part 2. There's a basic contrast here. The Hipaa privacy rule is much more disclosure friendly than the SUD records law. The Hipaa privacy rule permits a covered entity, those who have to comply with Hipaa, without the patient's consent, to disclose protected information to other persons and entities for treatment activities, payment activities, or healthcare operations. Treatment activities means sharing information with other healthcare providers to coordinate care and treatment. Payment activities means submitting information, making a claim for reimbursement, or submitting information to a health plan or MCO to get authorization to provide services. So the Hipaa privacy rule for healthcare for covered entities says you don't need patient consent to share information for these 3 purposes: treatment activities, payment activities, or healthcare operations. On the other hand, 42 CFR Part 2 has always said, and still says, that to disclose for a SUD treatment program, to disclose information for treatment, payment, or healthcare operations, you have to have patient consent. And the only treatment exception is if there's a medical emergency. There's a specific provision on that. So as you can see, Hipaa allows much more information sharing than 42 CFR Part 2. So what does the CARES Act say? It says in an SUD program, a patient may consent to the disclosure of SUD records for treatment, payment, or healthcare operations. Now, I think that's a little bit curious because SUD programs are required to get consent to release information for these purposes, and they've always been permitted and actually do get consent, patient consent, to release information to others for these purposes. So this is not a change in law. However, this is in a section where Congress says, okay, we're going to talk about TPO. We're going to talk about treatment, payment, and healthcare operations. They then go on to say in the statute, the amended statute, that the patient may consent once to all future treatment, payment, healthcare operations disclosures until the patient revokes consent. I'm not sure how DHHS is going to implement this. I'm not sure what this means. I'm not sure even how this is really a change. If I give my SUD program, if I'm an SUD program patient and I sign a consent authorizing the program, my SUD treatment provider, to disclose information to my health plan or health insurance company for payment purposes, I don't need to sign a new consent each time a disclosure is made. I can sign that consent and it can be, and I can write that this consent is good until I stop receiving services from you. So I'm not sure how this is a change, and we'll have to see when the rules come out. But what I can tell you is a fundamental change is that once information is disclosed for treatment, payment, or healthcare operations from an SUD program with patient consent to some other entity, that recipient entity can then redisclose the information in accordance with the Hipaa privacy rule. So again, let me say that prior to CARES Act implementation, I actually have not said this before, but we're going to get into this. When an SUD program shares SUD patient information with another entity that's not an SUD program and not otherwise bound by 42 CFR Part 2 to a primary care provider, for example, when that primary care provider under current law receives that information, even if that primary care provider has only worried about the HIPAA privacy rule or about complying with that rule heretofore, once they receive the SUD treatment information, they then must comply with 42 CFR Part 2 when it comes to redisclosing any of the SUD treatment information. The recipient of SUD program information is called a lawful holder and must follow the law, 42 CFR Part 2, when it comes to redisclosing that information. So if you receive SUD program information, even if you're not an SUD program, the law attaches to the information that you receive, and you have to follow the law with respect to that information before disclosing it to others. What Congress says here is if you're a HIPAA covered entity and you receive SUD program information, then with the consent of the patient, then you only have to follow the HIPAA privacy rule when it comes to redisclosing that information. That's a big change. Let me ask you this. Here's a true or false question. The state law governing the confidentiality of behavioral health records has a similar provision to what I just discussed. It permits a HIPAA-covered entity that has received confidential information from a GS 122C facility to redisclose that information in accordance with the HIPAA privacy rule. The state mental health confidentiality law need not apply to a covered entity's redisclosure of that state protected information. True or false? Just letting you know, Alex, so far I cannot see responses, but I assume I will in a moment. Interesting. It's roughly half and half. The answer is true. I point you to the following provision. Let me try to move the slide. I'm not able to advance the slide. Let's see. Okay, here we go. It happens to be true that there is a particular provision in the state law governing the confidentiality of behavioral health records that says the following: a HIPAA covered entity or business associate receiving confidential information that has been disclosed pursuant to, these are the citations for the confidentiality law, may use and disclose, really we're talking about redisclose, such information as permitted or required by the HIPAA privacy rule. So a facility or an MHIDD SUD provider must follow GS 122C when it comes to securing, protecting, and disclosing MHIDD or SUD treatment information under state law. However, our state law says that once that information is disclosed pursuant to the state behavioral health records law, if the entity receiving it is a covered entity under HIPAA, covered entity or business associate, then it only needs to follow the HIPAA privacy rule. It can forget about the state behavioral health confidentiality provisions. It only needs to follow the HIPAA, comply with the HIPAA privacy rule when redisclosing that information. Now, if you're a recipient, if the recipient of information is not a covered entity under the HIPAA privacy rule, you then do have to continue to follow the state mental health law. You do need to know 122C 53 through sections 56, because even if you're not a mental health provider, an IDD or SUD provider, if you receive information from such a provider, if you're not a HIPAA covered entity, then you do have to continue to follow the state law governing the confidentiality of behavioral health records when it comes to redisclosing that law, when it comes to redisclosing that information. Okay, continuing with the CARES Act. It changes the penalty enforcement and penalty provisions. It says SUD programs are going to be subject to the same penalty structure as HIPAA covered entities, meaning you could be subject to the same civil monetary penalties. And instead of the Department of Justice, which currently enforces 42 CFR Part 2, the Office of Civil Rights, OCR, will enforce the SUD law just like it enforces the HIPAA privacy rule. And it imposes the HIPAA breach notification rules on to SUD programs. Now, most SUD programs in North Carolina that I'm aware of, most agencies providing diagnosis or treatment for substance use are probably also already covered by the HIPAA privacy rule, and therefore should be familiar with HIPAA's breach notification rules. The point here of the change in the law is that the HIPAA breach notification rules will apply to SUD programs. Congress also added some anti-discrimination provisions to try to make sure the SUD information would not be used for discriminatory purposes. And it also expanded the prohibition on use of SUD patient information in judicial proceedings. There is already a bar on the use of information in criminal investigations and proceedings unless a court order is obtained. They've expanded that to include civil, administrative, or legislative proceedings conducted by any federal, state, or local authority against the patient, unless a court orders disclosure. So notice it's not all civil proceedings, like in a family law case, parent against parent. It applies to a proceeding conducted by a federal, state, or local authority against the patient. Perhaps I should say we're going to have to wait and see how DHHS writes the regulations implementing this? There's a number of questions we could talk about, but just keep in mind that it's expanding from criminal to other proceedings, the bar on use of SUD patient information, unless a court issues an order. Finally, there are a few other CARES Act changes. The legislation encourages SUD programs to access their state-based prescription drug monitoring program when clinically appropriate. And it requires SUD programs to give to the patient upon admission to treatment services or upon admission to SUD services, something similar to the Hipaa Notice of Privacy Practices. Now, currently under 42 CFR Part 2, SUD programs are required to give patients a statement about the privacy of their information. The legislation requires that statement be now more robust and contain more information, which seems to me, when I read the legislation, very similar to the Hipaa Notice of Privacy Practices. Now, again, for SUD programs that are already covered entities, this should not be a big deal because you already do that for your patients. Okay, before going on, are there any questions on the CARES Act before we go and talk about the CARES Act is our forthcoming changes? I want to go on and talk about current law, including the August 2020 changes.
So we do have quite a few questions, Mark, and you can just tell me if we'll cover these later as you get in further into the presentation. There are a couple of questions specific to disclosures after death. So for example, can records be sent if a person is deceased and then obviously cannot sign a release of information? There's one general question about that and then one more specific. Do you want to cover that now or later?
Well, that question, so first of all, I'm asking if are there any questions regarding the CARES Act. With respect to deceased patients, there is a provision in the North Carolina Administrative Code that implements GS 122C confidentiality statutes that talks about the records of a deceased person. I don't remember exactly what it says. I would have to go and look at that regulation.
Okay.
And I believe I believe, however, that it refers, this would be in what used to be called APSM 45-1 manual. It's also in the administrative code. If this and other questions I cannot answer can be collected, I can answer post program. But I believe that, and to be sure, I'd have to go check that regulation, but I believe it says that the next of kin, an executor for the estate can sign a consent for release of information regarding a deceased person. If there's no executor, then it would be next of kin. What was the other question?
The other one is more specific. We can talk about that one a little bit later. I think there were several questions though also related to the length of time that the consent would be valid for.
I'll get to that.
Okay, you'll get to that later.
I have a whole section on patient authorization.
Okay. One other question, does the exception for medical emergency include the commitment process? That was in one of the beginning slides, I believe.
We'll have to put that in the parking lot, something that I answer later.
Okay, all right.
Okay.
I think that's it for now then. One question is the managed care, the LME MCOs, are they considered a provider?
Are they considered an SUD program?
The question is, are they considered a provider? So I assume that means a treatment provider, I guess.
No. So for purposes of 42 CFR Part 2, they are a lawful holder of SUD patient information, therefore must comply with 42 CFR Part 2. But they are not an SUD program or Part 2 program.
Okay, thank you. And then one final question is just a request to possibly include verbal consent related to telehealth services, as we've opened up those flexibilities for telehealth now. If you can talk a little
Verbal,
bit about that.
so under both 42 CFR Part 2 and GS 122C, verbal consent is not permitted. Consent, authorization to release patient information has to be in writing. And again, I'll get to patient authorizations down the track here, okay?
Okay. Thank you, Mark. I think we can move on.
All right, sounds good. Let me just get my papers in order here. Okay. Let's talk about current law. Let's move beyond the CARES Act. 42 CFR Part 2, the regulation governs SUD treatment records. It restricts the use and disclosure of patient information obtained by a federally assisted alcohol or drug abuse program. See the words in quotations? Those are all words that are defined in the regulation. A little bit later, I'm going to distinguish what use between use and disclosure and what those two terms mean. Federally assisted, sometimes that's an issue because you could provide SUD treatment without being federally assisted, but it's pretty easily to be federally assisted. If you receive federal block grant funds through the state, if you're 501c3 status, tax status can make you federally assisted. It's pretty easy to be federally assisted. I will say a few things about the terms use and disclosure later on. I'm going to focus on the word program because that determines if you are a treatment provider that has to follow these rules. So a program, I'm going to use when I use program in this presentation, I'm referring to what some people call a Part 2 program, which means a person or entity that has to comply with 42 CFR Part 2. I may use the term SUD program. These three words will mean, for purposes of this presentation and in the law, means any individual or entity other than a general medical facility like a hospital or hospital emergency department that provides and holds itself out as providing SUD diagnosis, treatment, or referral for treatment. Now let's set aside the exception for general medical facilities. I will get to that a little bit later. But as a general matter, any individual or entity that provides and holds itself out as providing diagnosis, treatment, or referral for treatment for substance use disorder is a person or entity that's subject to this law. So we're going to poll you again, and I'm going to ask you, can anyone other than a program be subject to the law? Yes or no? Now, you guys should get this one right because this has been mentioned. It's been at least implied, but soon we will get very explicit about this. Excellent. I can see that I'm going to have to drink a little coffee to keep up with you folks. You're really on the ball here. The answer is yes. And let's talk about that a little bit. If I can manage to advance the slide. Let's look at what information is protected. The law talks about who is covered by the law, who it applies to, programs. It also talks about what information is protected. And the federal confidentiality law governing SUD patient records says that the restrictions on disclosure apply to any information that would directly or indirectly identify a patient. That means when a law enforcement officer comes to a residential SUD treatment program and says, hey, I have this subpoena or this arrest warrant, I need to serve or mark bots. Is he here? You cannot even say, if you're working for that SUD program, that I'm there. You cannot even say that I am a patient, because that would identify me. So any information that would directly or indirectly identify a patient, and the term patient is defined itself, you'll see on the slide. Anyone who has applied for or been given diagnosis, treatment, or referral for treatment as having or having had a substance use disorder, and is drug or alcohol abuse information obtained by a program for the purpose of treating a substance use disorder, making a diagnosis for that treatment, or making a referral for that treatment. So think about this. If you're not an SUD program, but you obtain information from an SUD program about a patient, and that the SUD program itself obtained for purposes of providing diagnosis, treatment, or referral for treatment, if the information you obtain had been obtained by the SUD program for these purposes, you are holding protected information, even though you're not on an SUD program. In other words, when an SUD program has this kind of information, the information fitting this definition, and passes it on to someone else, that information still fits this definition. So the restrictions on disclosure apply to programs, and I'm going to get in more detail into the definitions of program, okay? Just hold that thought for the moment. But it not only applies to SUD programs, but it applies to what the regulations call lawful holders of protected information. Those who lawfully receive information from a program or other lawful holder. Now, I'm going to spend some time talking about programs and talking about lawful holders. One of the reasons I'm going to talk about lawful holders, those who receive information from an SUD program, is because some of the August 2020 rule changes specifically address the responsibilities of lawful holders. Those non-SUD programs, those non-Part 2 entities that receive SUD information from an SUD program. So let me ask you this. We're going to do another poll. You get to answer another question. Which of the following are lawful holders? A primary care provider who receives SUD program information pursuant to patient consent, a Department of Social Services that receives SUD program information pursuant to the consent of a parent in the protective services phase of a child welfare case, or a probation officer who receives SUD program information with the consent of a criminal offender in SUD treatment, or is it all of the above? What say you? And 96% of the folks here are correct. It is all of the above. So we can say with confidence that the restrictions on disclosure apply to anyone who receives information from a program and is notified of the restrictions. Now, I said I would get back to the word use. So in HIPAA privacy rule parlance, which uses the word use a lot, it talks about use and disclosure. Use is referring to information shared and disclosed and exchanged internally within a provider agency. And disclosure in HIPAA parlance means information that leaves the covered entity and goes out to someone else. Here, the word use has a different meaning. It's when the regulation talks about restrictions on use, it's talking about use in judicial proceedings. And in specifically right now, the word use is limited to where the regulations talk about use of information, patient information, whether obtained lawfully or unlawfully, use of that information in criminal investigations and proceedings is prohibited unless there is a court order that allows it. So that's really the only place where use, the term use, shows up in 42 CFR Part 2. The restrictions on disclosure mean you cannot disclose except as permitted by 42 CFR Part 2. The restrictions on disclosure apply to SUD programs and those who receive information from SUD programs called lawful holders. The restrictions on use apply to the use of information in the specific context I just described. So let's talk about programs, and then we're going to talk about lawful holders, okay? And then we'll talk about how programs and lawful holders can disclose when, whether they can disclose or when or how, when required by other law through patient authorization or with court orders. So we're going to talk about programs, then I'm going to talk about lawful holders, and then we'll talk about disclosures as required by law or through patient authorization or via court order. Programs. By the way, I've been using the term substance use disorder or the acronym SUD. A few years ago, the definition in 42 CFR Part 2 for alcohol and drug abuse changed to the term substance use disorder was changed, and this is how it is currently defined, okay? You'll notice that there is one apparently socially acceptable and therefore excluded from the definition kind of substance use, and that is tobacco and caffeine. So there are actually 3 different definitions of programs. I gave you this definition a moment ago. An individual or entity that provides and holds itself out as providing SUD diagnosis, treatment, or referral for treatment. The other 2 definitions have to do with general medical facilities. I'll get to those in a moment. So for example, a private practitioner who provides and holds herself out as providing diagnosis and referral for treatment is covered by the regulations, even though she might not treat SUD. Anyone who provides diagnosis, treatment, or referral for treatment. So now let's talk about definitions 2 and 3. Definition 2 says an identified unit within a general medical facility that provides and holds itself out as providing diagnosis, treatment, or referral for treatment is also a program. So this is an example of that definition or how it would apply. If a general hospital has promoted to the public an identified unit, such as a detox unit, as a provider of such services, then the identified unit, but not the rest of the general hospital, would be a program. So a general hospital, community hospital, acute care hospital that has a detox unit, the detox unit is a program, but not the larger hospital facility. The detox is an identified unit within a general medical facility. So the third definition applies to general medical facilities. It says that personnel in a general medical facility whose primary function is the provision of SUD diagnosis, treatment, or referral for treatment, and who are identified by such. So, for example, this means that just because a hospital emergency department staff refers a patient to the hospital's ICU for an apparent drug overdose, that person making that referral to ICU from the ED is not an SUD program unless such things are the primary function of such staff. Let's provide some illustrations, but I have another question for the class. This is the scenario. Patient is treated for an apparent drug overdose, is transferred from the emergency department to a medical floor. A substance abuse counselor visits and evaluates the patient for substance use disorder on the medical floor and evaluates the patient for possible referral for treatment. Is the substance abuse counselor a program under 42 CFR Part 2? Yes or no? And the answer is yes. The answer is yes, because although the substance abuse counselor is in a general medical facility, or they are a person whose primary purpose, whose primary function is the provision of SUD diagnosis, treatment, or referral for treatment. You might ask, what is a general medical facility? What might that term apply to? Well, it's not defined in the rule, but SAMHSA, the Substance Abuse Mental Health Services Administration, says it may include hospitals, trauma centers, federally qualified health centers, and practices comprised of primary care providers. All of those might be considered a general medical facility. So let's talk about this definition of programs a little bit more. What the rule, the SUD confidentiality law, is saying is that healthcare providers who work in these facilities, primary care practice, general hospital, would only be a program if they work in an identified unit within the facility that provides diagnosis, treatment, or referral for SUD treatment, or the primary function of the provider is the provision of such services and they're identified as providers of such services. Now, again, we're talking about who is a program for purposes of folks that work in a general medical facility. Definitions 2 and 3 of program, meaning Part 2 program or SUD program. Looks like I have another question to try to flesh this out. You guys are doing very good so far, which pleases me greatly. Okay, question. Dr. Mallory is an addiction specialist who works in a community health center that provides primary care, pregnancy care, and geriatric care. Dr. Mallory treats patients who have substance use disorders and prescribes buprenorphine for opiate addiction as part of her practice. Is Dr. Mallory, actually, I don't think I have a poll for this. This is one I just walked through, right, Dee Dee or Alex?
Correct.
Okay, so is Dr. Mallory covered by 42 CFR Part 2? Yes, Dr. Mallory is a person within a general medical facility whose primary purpose is to provide SUD treatment. Now, is the larger community health center covered? No. The answer to that would be no. So only Dr. Mallory is an SUD program, assuming that there's no one else in the community health center that does these kinds of things. So what that means is Dr. Mallory, when it comes to sharing information with other providers in the community health center, may have to follow 42 CFR Part 2, and we're going to get into that a little bit with some rule changes. Dr. Mallory has to be concerned about sharing his patient information as an SUD program with others in the community health center. Dr. Mallory is either going to need patient authorization to do that, or going to need to have find some exceptions in 42 CFR Part 2 that allows the disclosure of information with others in the community health center, unless the community health center wants to consider itself as an SUD program, and then information can be shared internally. However, in that case, then everyone else in the community health center would have to know about 42 CFR Part 2 and follow 42 CFR Part 2 when it comes to disclosing information outside of the community health center. So there's some choices on how to manage this, but first of all, Dr. Mallory would look to patient authorization to share or some other provisions in the law, and there have been some changes to the law, which I'll get to in a little bit. Let me say, the changes are not with respect to whether Dr. Mallory can disclose, but whether, if he discloses pursuant to 42 CFR Part 2, what are the obligations of others in the community health center? I'll get to that. Okay, so it looks like I do have a question for the class. Hospital emergency department is treating a trauma patient, and it performs a blood test that identifies cocaine in the patient's blood. Does this make the hospital emergency department a program? And if so, are the drug test results protected by 42 CFR Part 2? So this is a question about programs and a question about protected information. Okay, so the answers to these questions are no and no. And let me explain why. First of all, remember that when we're talking about a general medical facility, which the hospital emergency department is, we have to ask, is there an identified unit or there that holds itself out as providing SUD diagnosis, treatment, or referral for treatment? Alternatively, we would have to ask, is the primary purpose of the hospital ED or the person who administered the test, is their primary purpose SUD diagnosis, treatment, or referral for treatment? Probably not, because this discovery that cocaine was in the blood is something that was done likely by emergency clinicians providing general health care in an emergency trauma situation, okay? Unless their primary purpose, and the primary purpose of an ED is not SUD diagnosis, treatment, or referral for treatment. It may do that, but that's not its primary purpose when we're talking about programs definition for hospitals, general medical facilities. It's not it may provide that kind of treatment, but that's not its primary purpose. Its primary purpose is to provide emergency care and treatment for any and all healthcare conditions. And unless the person drawing the blood or the person or the lab, unless their primary purpose is to provide SUD diagnosis, treatment, or referral for treatment, the answer is no. And let's look at, assuming you have a program, would the information be protected? Let's go back and look at the definition of protected information. Any information that would directly or indirectly identify a patient. So if this individual comes in, a trauma patient from a car accident or a fight, does finding out that cocaine is in their blood, does that mean we're dealing with someone who has applied for or been given SUD diagnosis, treatment, or referral for treatment? The blood lab identifying substances in the blood alone does not make this person a patient under that definition. Is the positive test for cocaine in the hospital ED when drawing blood on a trauma patient, is that information obtained by a program? No, again, we discussed program. It's very unlikely in this scenario I gave that we're dealing with a program. But assuming that it is, was it obtained for the purpose of treating SUD or making a diagnosis for that treatment or making a referral for treatment? Probably not. I would say almost definitely not. Rather, the blood was being drawn to see what substances are in the blood to make sure that when we're treating the person and providing other medications, there are no contraindications with those medications. So my answers would be no and no. Let's go on. I have another question. And after this question, we'll talk about lawful holders. Dr. Smith is a primary care physician. At every physical, she spends 5 minutes asking the patient a list of universal screening questions for risky substance use. If the patient meets criteria for risky use, Dr. Smith has a short discussion with the patient and, if appropriate, provides a referral for further assessment and possible treatment. Smith includes this screening, brief intervention, and referral for treatment screening results in her patient records. Are the expert screening results protected by 42 CFR Part 2? Yes or no? Interesting. Okay. About 68% of you said yes, about 32% of you said no. So this is a little difficult and a little tricky, this question here. If one were to focus on the name of the screening tool or process here, screening, brief intervention, and referral for treatment, because 42 CFR Part 2 says it applies to persons or entities that diagnose, treat, or refer for treatment, you might say that the information garnered through this expert screening result is protected by 42 CFR Part 2. On the other hand, if this screening tool is like some of you out in the field might be familiar with what's called an audit or DAST, D-A-S-T screening tool. If this screening tool simply asks questions like, how often do you drink, and do you have trouble getting up in the morning after drinking, some things like that. If this tool is really used by Dr. Smith to determine if the patient might have an SUD, and if she believes the person might have a substance use disorder and is referring for further evaluation or assessment by a substance abuse professional, then that stops short of information protected by 42 CFR Part 2. So if Dr. Smith says, oh, I'm diagnosing you, and she enters into the record something that could be considered a diagnosis, then that would fit the definition of information covered by 42 CFR Part 2. But if rather than diagnosing or asserting that she's diagnosing, if instead she says, based on this list of questions asking about your behaviors, based on that, I'm going to refer you for an evaluation or assessment, then that information is not covered by 42 CFR Part 2. So the distinction here is, and I'm going to go ahead and close this. The distinction here, if you want to try to put it in a nutshell, is between referring for treatment versus referring for assessment or evaluation. If you conceptualize it as referring for treatment, then you're talking about information protected by 42 CFR Part 2. If you're conceptualizing it as, oh, I'm not making a diagnosis, I'm gathering some information, which then leads me to refer for an evaluation or assessment of SUD, then that information is not information protected by 42 CFR Part 2. So there is a fine line distinction here, and it really depends on the nature of the tool, how the doctor's using it, and how the doctor is documenting the results. Now I'm going to move on to lawful holders. First I'm going to ask, are there any questions related? I can take a couple of questions if there are questions related to the definition of program. We'll limit this to the definition of program, which I just covered.
There are a lot of questions, Mark. I think maybe during the break, all of us should probably get together and figure out a better way to address most of these. I do have a couple of questions related to expert, if you're okay with that.
Mm-hmm.
So one of the questions is, if the physician puts the diagnosis on a claim or bills for expert, is she then considered a covered program?
Well, billing for the activity of expert?
Yes. Mm-hmm.
No, I mean, unless if she does something that looks like making a diagnosis, then we're talking yes. So this really depends on how it's coded and what words are used and how it's documented. That's going to be the evidence of what the activity is. And I know that's like not a clear answer, but that is the best answer. until and unless I can actually see the records. Do you have another question? I'll take one more, and then for the sake of time, we should probably keep moving.
So here's one related to programs in a hospital setting. How does 42 CFR relate to an SUD clinician in a hospital setting that utilizes electronic health records that other providers in the hospital are able to see?
Well, and you're talking about an SUD clinician?
So that's the question, yes.
Okay, so the first step in the analysis is this clinician a program, Part 2 program, okay? Assuming they are, then there needs to be further discussion with under what provision. So if he is a SUD program, 42 CFR Part 2 applies, and then the question would be, if others are accessing those records, they either have to be considered part of the SUD program, or you need to look to the SUD law and say, well, what provision of that law permits the doctor, the SUD program, to share information with non-Part 2 programs, with non-SUD programs? So the bottom line here is there needs to be a conversation in that scenario. Folks need to discuss, well, first, the bottom line is an SUD program cannot disclose information to others unless there's patient consent or some other provision of the rule permits it. So they cannot just say, oh, we're all working at the hospital, we don't need to worry about it. When that information moves from the SUD provider to others via the electronic system, you've got a problem, unless there's some segmentation or control over who accesses it. And again, that would require some further conversation. So let me go on now, Dee Dee. We can talk about how to handle some of the questions at the break. I'm going to go and try to get a little more in because we have to take a break in 10 minutes. Okay, I'm going to talk about, we talked about programs. I want to talk about lawful holders. And this is where some of the August 2020 rule changes come in. So SUD program information can be disclosed pursuant to the patient's written consent to another healthcare provider for purposes of coordinating care and treatment, to a health plan to obtain payment for services. The first one, Hipaa calls a treatment activity. The second one, Hipaa calls a payment activity. If you're a Hipaa covered entity disclosing information for those purposes, you don't need patient consent. But here we're talking about an SUD patient information. The program needs patient consent to share information in those two scenarios. It also needs the patient's consent to share information with others to carry out payment or healthcare operations for the SUD program. Say the SUD program has a vendor or a contractor that does billing for services. That's a payment activity. The SUD program needs to have patient consent to share information, disclose information for that payment activity. When the SUD program patient wants to share information with DSS because it's in their interest to prove to DSS that while I'm in protective services, I'm actually complying with treatment, SUD treatment, that requires patient consent. And patient consent is required for an SUD program to share information with a probation officer. In all of these situations, all the recipient entities are lawful holders. The August 2020 final rule loosens restrictions on redisclosure for some lawful holders, but not others. Those lawful holders that receive SUD information for treatment purposes and payment and healthcare operations, there's some loosening of the rules with respect to them redisclosing information that they receive from an SUD program. So this is what it says. First, we're going to talk about two things that have to do with a lawful holder that receives information for treatment purposes. We're talking about a non-Part 2 program, a non-SUD program that receives information conveyed orally for treatment purposes. What the 2020 rule change says is we're not going to consider that as falling within the definition of record. We're not going to consider that as protected information. Therefore, the rules governing redisclosure of that information do not apply. Again, this is information conveyed orally, and if it's reduced in writing by the non-Part 2 program recipient, say a primary care provider, that documentation is not governed by 42 CFR Part 2. So this is the example. A healthcare provider, with the consent of the patient, orally receives information from the patient's SUD provider, subsequently engages the patient in an independent conversation through her own clinical counter about the patient's SUD and treatment, and then records SUD information received from the SUD provider and or the patient. So again, non-SUD provider, non-Part 2 provider receives information pursuant to patient consent from an SUD program, uses that information to talk to the patient, and then after that, makes a clinical note that may include what he or she received orally from the SUD program and may include information that she received from the patient. This information is not governed by 42 CFR Part 2 restrictions on disclosure, meaning you don't have to follow 42 CFR Part 2 when it comes to redisclosing that. Now, a treating provider that receives FUD information, there's another rule change, another aspect to the rule change. The August 2020 rule was changed in a way to say that if a non-Part 2 treating provider receives protected SUD information from a program or other lawful holder in electronic or paper form and segments or segregates that information from its own patient records, then only the segmented documents and not its own patient records are governed by 42 CFR Part 2. Now, just bear with me. I know I'm throwing a lot. I'm going to walk through this and explain it, and I'm going to be a little redundant here, okay? Let me get a few more slides in to allow you to digest this. By the way, segregated, it refers to paper copies. Segmented refers to electronic records. So what this means is the act of recording SUD patient identifying information in the non-Part 2 provider's own medical record does not by itself render the medical record subject to 42 CFR Part 2. So that's true of information received orally that gets documented in the non-Part 2 treatment provider's record. But also, if that primary care physician reads information from documents and records received, and some of that works its way into her own record, that also is not covered. But as long as the documents themselves, electronic or paper, are segmented or segregated, and those would continue to be covered. So why this change? This affects, again, someone who receives information for treatment purposes. And someone that's not an SUD program that receives SUD patient information for treatment purposes. By saying that some of this information is not a record covered by 42 CFR Part 2, then the rules, restrictions on disclosure do not apply. And only presumably the Hipaa privacy rule would apply to the redisclosure. The intent is to allow the Part 2 program to make a disclosure with the patient's consent to the recipient provider. In turn, that provider can then carry out her own encounter with the patient and create her own patient record, which will not fall under the coverage of Part 2. He or she just needs to segment or segregate the actual documents that were received from the SUD program. They will remain covered. So this is an amendment to section 2.11 and 2.12 of the federal regulations governing SUD treatment information. Let's, at the risk of being redundant, let's walk through this a little more. SUD program makes oral and non-oral communications with the consent. You still need patient consent for the SUD program to disclose to a non-Part 2 provider, a non-SUD program, who is treating the patient. And the information is disclosed for treatment purposes. The provider, informed by that information, then has her own direct clinical encounter and conversation with the patient. The provider's independent record of the encounter may include SUD content from both the patient and the program. The non-SUD provider's record of her patient encounter does not fall under 42 CFR Part 2, assuming the provider received it for treatment purposes, and any non-oral communication, electronic or paper, is segregated or segmented from the rest of the provider's record. So I have one more question, which we can maybe get in before the break. And that is, revisions that I've just discussed apply to a non-Part 2 provider who receives SUD treatment information for treatment purposes. Do they change the obligations of other lawful holders, recipients of information from SUD programs, such as the child welfare system or the criminal, that should read, or the criminal justice system? Yes or no? And the answer is, and the correct answer is no, because the changes I just discussed apply to a lawful holder who receives information for treatment purposes, a treating provider. When GSS receives information regarding a parent and protective services, they are receiving information to monitor compliance with treatment, to make sure the mom, for example, is going to treatment, not so they can provide treatment themselves. Same with the criminal justice system. Probation officer, parole officer might be receiving information about treatment, but they're not receiving it for the purpose of providing their own treatment. So the changes I discussed apply only to a provider of services who's receiving the information for treatment purposes. The answer is no. I'm going to start up now, and I want to tell folks that I did see 2 questions in the chat that I wanted to respond to. I believe one was from Sherry, and it was relating to the use of an SUD program stamp, redisclosure prohibited, and that still applies. So let me clarify, when an SUD program sends information to a non-Part 2 program for treatment purposes, a treating provider that's not covered by 42 CFR Part 2, whether electronic or in paper, those documents are still covered by 42 CFR Part 2. And when I said that the program can segment those, when I was talking about segmentation or segregation, let me clarify. If those documents, electronic paper, are received by a non-SUD program for treatment purposes pursuant to the patient's consent, if that provider puts those into their regular records, then they're making all their records subject to SUD. If they segment or segregate the 42 CFR Part 2 records, then the rest of the healthcare records are not governed by 42 CFR Part 2, but the segmented or segregated information is. So either way, electronic or non-oral information continues to be covered by 42 CFR Part 2. The segmentation segregation rule is just for the convenience of the treating provider. If they segment or segregate those documents, then the rest of their record is not covered by 42 CFR Part 2. Also, if they happen to take information orally from the SUD provider, or they have information that they read from the records, and some of that makes its way into the regular overall medical record, that's not covered by 42 CFR Part 2, but the original documents are. And then there was a question about how can I explain all this to my patients or clients, because many who have only a 10th grade education. So, and I'm not sure if that came in from an SUD program provider or other treating provider, but I think the key issue is if you're an SUD program and you admit someone to a service, you have to give them a statement, and it's going to change now and be more like a notice of privacy practice. You have to give them a statement telling them about how that their information is confidential and how it may be used. Some of the exceptions of confidentiality. That should be written in plain English. That's one basic encounter about all this stuff between provider and patient. The other basic encounter is when you want to disclose information to someone else and you need patient consent, you then do it through a written consent form. So when managing the patient's awareness and the patient's rights with respect to this information, two key encounter moments are when they come in to service, they're admitted to service. I would focus on a plain English document that explains what their confidentiality rights. And then if they have a need for interest in disclosure outside an SUD program to another treatment provider, or if some other lawful holder needs patient consent to redisclose, you then focus on the written authorization form, the document. And I'll give some examples. And that's something that you then have to try to put in plain English while also explaining, covering all the bases of the law. So when it comes to being able to take all this and explain it to the patient, I would focus on those two encounters, admission and then authorization to disclose. And then the document you use, and you could walk through it orally with the patient, the document you use for that purpose then focuses you, and the requirements for those documents focuses you on how to talk to that patient and what you need to say. Okay, so I still have my PowerPoint shared, correct? Let's see.
No, you'll have to reshare.
Okay. Got it. Give me a second. Here it's coming. Okay, so you should see a slide that says not all lawful holders are equal.
Yes.
And then it starts with mom and then ends with, in this scenario, colon. Is that what everyone sees?
Yes.
Okay, great. So this is following up on the fact that the rule changes I just walked you through apply to certain lawful holders, but not other lawful holders. what I talked to you about so far applies to lawful holders of information for treatment purposes. Now, and then I asked you a question about DSS or criminal justice system for lawful holders. And the answer was no, what I talked about did not apply to them. Let's look at this scenario. Mom in a protective services phase of a child welfare case agrees to get SUD treatment and signs a consent to disclose information about that treatment to DSS. So the Child Protective Services personnel can monitor mom's attendance and progress in treatment. A Child Protective Services worker receives SUD information from the program orally and writes it down in her case file. Now, if you were receiving it for treatment purposes, that would not be information, even though written, that is subject to the restrictions on disclosure and redisclosure that we find in 42 CFR Part 2. But in this scenario, is DSS a lawful holder of SUD information would be the first question. And the answer is yes. It's lawful because they received the information pursuant to patient consent or written authorization. It's SUD information governed by 42 CFR Part 2 because it's information that identifies someone as a patient of services and it's about their SUD and their treatment. Is the oral information a record? Does it fall within the definition of record? And therefore 42 CFR Part 2 applies. The answer is yes, because the exception to oral information being a record, again, applies to someone who receives the information, someone who is a treating provider who receives information for treatment purposes. And that's not the case here. And so then we get to the next question. DSS is a lawful holder. The information is subject to 42 CFR Part 2. It is information that's protected by that law. So then the next question is, does that law's restrictions on disclosure govern DSS's redisclosure of the information? And the answer is yes. So there is a state law provision. There's a law in the confidentiality statutes governing MHIDD SUD information, state provision, that is similar. It says no individual having access to confidential information from a facility, that's MHIDD SUD treatment information, may disclose it except as authorized by the state confidentiality law itself and its implementing regulations. So even though earlier I pointed out to you that there's an exception to this for Hipaa covered entities that lawfully receive information pursuant to 122C. Other than Hipaa covered entities, if you receive such information, then you are what the federal rule calls a lawful holder, but what state law here calls an individual. So the parallel between state law governing behavioral health care information and the federal law governing SUD treatment information, the parallel between those two confidentiality laws is that they both say when someone receives information covered by this statute pursuant to the rules covered by these regulations or statute, when you receive information that's confidential under either, that information is still confidential. And as a recipient of that information, you have to follow that law, those two laws, when it comes to redisclosing the information. Even if otherwise you don't think about those two laws because you're not a mental health provider or a SUD treatment provider. If you receive information that's protected, it continues to be protected. And again, the state law says, well, there's an exception for Hipaa covered entities. And the SUD law says there's an exception for treating providers who receive information for treatment purposes. Otherwise, when it comes to redisclosing information governed by those two laws that you might not otherwise think about or know much about, when it comes to redisclosing that information, you have to follow those laws. The receipt of that information creates a duty on your part. So let's look and see what the August 2020 rule says about, it says more about lawful holders. We talked about lawful holders who receive information for treatment purposes. Now, this is going to be a little review of the 2017 and 2018 changes, as well as the 2020 changes. I call all the last 3 years for this particular subtopic recent changes. So in 2017, the rule was changed to establish that if a patient consents to disclosure for payment or healthcare operations activities, the lawful holder who receives records under that consent may redisclose its records without further patient consent to its contractors, subcontractors, or other legal representatives to carry out payment and healthcare operations on the behalf of the lawful holder. So this is analogous to the lawful holder of the SUD treatment information having what Hipaa calls a business associate that helps the lawful holder perform some of its functions or carry out some of its activities. So the SUD program needs patient consent to disclose information to a lawful holder for these purposes, but the lawful holder does not need patient consent to disclose it to contractors who are helping it carry out or that are carrying out payment and healthcare operations activities on behalf of the lawful holder. So this allows, for example, an LME MCO may get information, SUD treatment information pursuant to the consent of a patient who's being treated by a contracted, an SUD program contracting with LME MCO. A Medicaid agency or vendor may get information pursuant to the patient's consent to disclose for payment activities. What this rule does, it allows those recipients to redisclose to their contracted entities without patient consent. Now, the previous rule and language, various things in the previous rule and the preamble to the previous rule explicitly excluded care coordination, the terms care coordination and case management from its list of permissible payment and healthcare operations activities. And it also said, by the way, lawful holders of SUD information, you can disclose for payment and healthcare operations purposes, but not for treatment purposes without consent. So what the August 2020 rule did last year is it added care coordination and case management services in support of payment or healthcare operations to the disclosures that a lawful holder recipient of SUD information can disclose to its business associates or contracted entities. So some folks see these things as including a little bit of treatment activities. Some folks see it as including a little bit of healthcare operations activities. That's a discussion for another day. I just want you to be aware of this rule change. So SAMHSA also moved from the preamble to the text of the rule 18 categories of payment and healthcare operations that apply to the changes that I just talked about to you, that apply to a lawful holder's redisclosure without patient consent to its contracted entities. But it says, look, that's lengthy, but it's non-exhaustive, it's illustrative, it's just examples. There could be other things that are not included in the list. And what the rule does say, 42 CFR Part 2 does say, lawful holder, when you disclose information under this mechanism, redisclose information from an SUD program, your disclosures have to be limited to information necessary to carry out the stated purpose of the disclosure. Now, this gets a little esoteric, I know, and some of the, I'm going to try to wrap this up because I don't know that would apply to some of you. But in this situation, when a lawful holder has received SUD treatment information that's governed by 42 CFR Part 2, it can disclose it to its business associates or contracted agencies that are helping it carry out payment and healthcare operations. But it must have a written contract or some other legal instrument, and the contract or legal instrument must say things that are very similar to what a business associate agreement says. Requires the recipient to safeguard the information, requires recipients to report any breaches back to the lawful holder, and the lawful holder must furnish the contractor recipients the standard notice that an SUD program gives to any recipient of information when it discloses SUD program information to another entity. So, bottom line, the law applies to programs, and lawful holders of protected information, meaning those who lawfully receive information from a program or other lawful holder. So if you're a program or lawful holder, I said the restrictions on disclosure apply, you have to follow the rules, okay? Well, what does that mean? What are some of those rules? And what is your basic duty? If the rule applies to you as a program or lawful holder, what is your duty? Let me say some things about your basic duty, and then I'm going to get into disclosures required by law, and I'm going to talk about patient authorization, which is the primary tool for sharing information when the law doesn't otherwise permit you to. So your basic legal duty, if you're a program or a lawful holder, is you may not disclose confidential information unless you have a law, patient authorization, or court order that says you can. I mean, 42 CFR Part 2 is a pretty long document. GS 122C, its confidentiality provisions are several pages. The Hipaa privacy rule is many, many pages. What do all those confidentiality laws say? They all say what I'm showing you on the slide here, that if the information you have is confidential under those laws, then you can't disclose it unless you have a law, patient authorization, or court order that says you're permitted or required to disclose in the given circumstances you're faced with. So let's look at this example. Court orders Jackie to get drug treatment at Acme Drug Treatment Center as part of a plan to see if she might regain custody of her children. Now, you might ask, why would an agency call itself Acme? Many businesses called themselves Acme back in the days before things were online and we used Yellow Pages. And the idea was, well, Yellow Pages are alphabetical. So Acme was a very common term, but I diverge. Excuse me for that. Let's go on. Jackie authorizes Acme to share patient information with the Department of Social Services and the court to provide DSS and the court with the information they need to determine if I have made sufficient progress in treatment so as to regain custody of my children. This is a common use of a patient consent for release of information, also sometimes called a patient's written authorization to disclose. And patient authorization is permitted under the Hipaa privacy rule, the state confidentiality law, and the federal law governing SUD programs. So here's my question, and we're going to use the poll here, I believe. Continuing on the story about Jackie, we then have a law enforcement officer who requests information about Jackie from Acme, the SUD program. governed by 42 CFR Part 2. The officer explains that he is conducting a criminal investigation. He's doing very important things related to Jackie's abuse of her children. Can ACME comply with the officer's request? Yes or no? The answer is no, and I will explain in a moment. But first, I want to ask you one more question about this scenario, and then I will explain why the answer is no. Let's say the SUD program said to the officer no, which would be correct. So the officer says, well, I'm going to go to the Department of Social Services because I know or have heard they have received information from an SUD program. They are a lawful holder of SUD patient information regarding this mom. Maybe I can get information from them. So the officer goes to DSS, requests info about Jackie that DSS has received from ACME. The officer explains again that he's conducting a criminal investigation of Jackie. Can DSS comply with the officer's request? Yes or no? All right, I see the results here. Can DSS comply with the officer's request? 30% of you said yes, 71% of you said no. And the answer is no. And let me explain why by asking, I'm going to ask and walk through some questions and explain to you how you analyze this and arrive at the right answer, okay? So the first question you have to ask, is the information sought by the officer restricted from disclosure by 42 CFR Part 2? And the answer is yes. The information that ACME has and that DSS has is information obtained by an SUD program for purposes of providing SUD diagnosis and treatment to Jackie. It's protected information. And this is a situation where I said both a program and a lawful holder that's not an SUD program, but receives information from a program, both can be governed by the law. So you have ACME is the SUD program, the Part 2 program. DSS is the lawful holder. So you're dealing with information that's protected by 42 CFR Part 2. The question then is there a provision in that law that permits either of these entities to disclose patient information to the law enforcement officer in these circumstances? Remember I said if the information is confidential, then to disclose it, you need to either find a provision of law that permits disclosure, or you need to have patient authorization that permits disclosure, or a court order. So the first question, is there a provision in the law that permits the disclosure of information in these circumstances? The answer is no. There's no provision in 42 CFR Part 2 that allows either ACME or DSS to disclose this information without something more. Okay, so let's move from a law or a provision in the confidentiality rules that says you can, which there is none in this scenario. And let's ask, well, what about patient authorization? Does Jackie's written authorization permit disclosure to the law enforcement officer? And the answer is no. Jackie's written authorization permitted ACME to disclose to DSS. And both ACME and DSS are bound by the terms, bound by what that authorization says. So then we talked about a law or provision in the confidentiality law that permits redisclosure to the law enforcement officer. That's not going to work. There is no written authorization that permits disclosure. So what does the officer need? The officer would need a court order. And hopefully we will have time to cover court orders before this program's over. I have that slides coming up on that. So the answer is the officer would need a court order issued under the guidance and procedures and criteria set out in 42 CFR Part 2. So remember, when faced with a question, can you disclose this information or redisclose it? If you're an SED program, you're saying, can I disclose in this situation? If you're a lawful holder, can I redisclose in this information? Always ask yourself the following questions. This is a basic analysis. Is the information confidential under one or more confidentiality laws? You would ask the same question for Hipaa or state law or 42 CFR Part 2. If so, if you're dealing with confidential information, is there an exception to confidentiality that permits or requires disclosure in the circumstance at hand? And those would fall under one of three categories. So let's talk about where the first category, where there maybe is a policy exception to confidentiality, where there is a law that says that maybe someone is required to share information with someone else. And then I'll talk about patient authorization, and then I'll talk about court orders. Let's talk about disclosures required by state law. So in North Carolina, we have a number of laws that say in certain circumstances, a person or agency must share information with others, even if it's confidential. Let's look at some of those. There's a law that says if you suspect child abuse, neglect, or dependency, you have to report that to the Department of Social Services, even if that means you're disclosing confidential information that's otherwise confidential under some other law. In that same chapter of the North Carolina General Statutes, there's a law that says DSS, as part of its assessment of the report, can then go and demand information from others, and others have to give it, even if it's otherwise confidential. There's also a statute that says when a court appoints someone to be a guardian ad litem for a child, that by virtue of that appointment under state law, that GAL, guardian ad litem, has access to information, including confidential treatment information. And there's a statute and set of regulations that talk about various agencies that must, upon request of one of those agencies, share information in child welfare and juvenile cases. So these are situations where state law requires the sharing or disclosure of information, even if it might be confidential under the HIPAA privacy rule, state law governing MHIDD SUD services, or even 42 CFR Part 2. These laws basically say if the information is confidential, you must share it. But what does the federal law 42 CFR Part 2 say about these? Well, in fact, let's talk about all three laws. The state confidentiality law governing mental health services says that a provider shall disclose confidential information as required by other state or federal law. So in all those four scenarios I discussed in the preceding slide, even if the information is confidential under 122C, those four laws require disclosure when they apply. Now, the HIPAA privacy rule says that a covered entity, someone that is required to follow the HIPAA privacy rule, may disclose protected health information to the extent disclosure is required by law. So if I'm a primary care provider or some other healthcare provider, I'm not providing mental health or SUD services, I'm just governed by the HIPAA privacy rule. When circumstances arise where those four preceding state laws apply, I'm required to share confidential information. However, the federal law governing substance use disorder treatment information is different. There is no catch-all provision that permits disclosure of information when required by other law. Unlike the HIPAA privacy rule, unlike GS 122C. And in fact, 42 CFR Part 2 says patient records may be disclosed or used only as permitted by these regulations. So we need to look into the regulations to see if the federal regulations speak to any of the four circumstances. Do they have a provision that allows information sharing under those provisions of state law that require disclosure? Well, the federal law goes on to say no state law may authorize or compel any disclosure prohibited by these regulations. So just because a state law requires a disclosure, that doesn't mean you're permitted to disclose information, SUD program information that's restricted from disclosure by 42 CFR Part 2. And the federal regulations say where state law authorizes or compels disclosure, but it's not permitted by 42 CFR Part 2, the federal prohibition on disclosure stands. The only permitted disclosures, I mean, so what you would do in any of those four situations, four required by state law disclosures, you'd say, well, I'm going to read the rules and see if I can find some provision in there that says I can disclose in that situation. And the rules say if I can't, if these rules don't permit disclosure, then I cannot disclose, even though state law says I must. So if you read through the rules, there's really only two. One relates to the cause of death under laws requiring the collection of death or other vital statistics or permitting inquiry into the cause of death. That means the medical examiner can get SUD program information under state law that says they can have information under certain circumstances. The only other required by law provision that 42 CFR Part 2 speaks to is when necessary to comply with state law requiring the reporting of child abuse or neglect. So of those four laws that I discussed with you, excuse me a moment, I'm just, one of them is referred to, one of the situations is referred to in 42 CFR Part 2. And what the federal law says here, you know what? When necessary to comply with the state law that requires the reporting of child abuse or neglect, it's okay if you disclose information that otherwise would be confidential under 42 CFR Part 2. So let me ask you the following question. I believe we have a poll on this. This is the question. An SUD program may disclose patient information in which of the following situations? Again, may disclose protected information. A, to report suspected child abuse, neglect, or dependency under a state reporting law, or B, to respond to a DSS request for information when necessary to assess a report of child abuse, neglect, or dependency, or C, when a child's guardian ad litem requests information. Under which one of these following situations may the SUD program disclose information pursuant to state law? And the answer is A. I see that 77% of folks answered A, 12% of the people in attendance answered B, and 11% answered C. The correct answer is A. The federal law governing SUD patient information does not permit disclosure under scenarios B or C, but they do permit disclosure when necessary to comply with the law noted in answer A. I have another question for you. Just trying to keep you guys awake here, okay? Following scenario, Child Protective Services worker is investigating a report of child abuse or neglect and requests access to the child's mental health record. Mental health record. The family social history section of child mental health record states that mom, during the intake of the child, disclosed that she is hooked on pain pills. So this is a tough question, tougher than it looks, because what I'm asking here is something that incorporates that refers to a required by law disclosure that we say an SUD program cannot make normally. But it also, what I'm asking you here, remember in the analysis, before we get to whether there's a provision of law or patient authorization or a court order that permits disclosure, we also have to ask ourselves, is the information actually governed by the law? Is it confidential under law? So perhaps I've said too much. So the question is the information pertaining to the mom's opiate dependency information protected by 42 CFR Part 2? Yes or no? Interesting, it's about a 60-40 split. 39% said the information is protected by 42 CFR Part 2. 61% said no. And no is the correct answer. This information is not protected by 42 CFR Part 2. And let me tell you why. So it's true that if the information is protected, that there would be no provision in 42 CFR Part 2 that says that the treating provider can comply with the state law that says DSS can have access to this information for purposes of assessing a report of child abuse, neglect, or dependency. So However, we don't even get to, is there an exception to confidentiality? Because the information is not confidential under 42 CFR Part 2. Remember, earlier I said that the restrictions on disclosure apply to any information that would directly or indirectly identify a patient, one who has applied for or been given SUD diagnosis, treatment, referral for treatment. The mom is with her child in front of a mental health services provider. The mom is disclosing things about herself that goes into the social history, family history section of the child's mental health record. The mom is not applying for SUD treatment services. Also, I said a mental health provider, a mental health clinician treating the child. We don't even know if that mental health provider is part of a larger comprehensive agency that also provides SUD treatment. So we don't even know if we have a program. But certainly there's nothing to indicate in that scenario that the mother gave that information as part of the process of applying for treatment, or that the mental health counselor obtained the information for the purpose of treating the mother's substance use disorder. So the information itself is not covered by 42 CFR Part 2. Because it's not confidential under 42 CFR Part 2, and remember, this is the analysis. You ask if the federal confidentiality law applies, and in this case it doesn't. If it does, then the rule is disclosure is not permitted unless you can find an exception in the rule, the patient consents, or a court orders disclosure. Let's talk about patient authorization to disclose. So we talked about all these rules. They get rather complicated. The restrictions on disclosure apply to programs and lawful holders. When do the rules say they can disclose if you're a program or redisclose if you're a lawful holder? Just remember this. You could always disclose anything with patient authorization. And when in doubt, this is a way for you and the patient together to draft and write your own exception to the confidentiality law. When a patient signs this form, they are saying, in the following circumstances, you can disclose the following information for these purposes. Well, there are provisions in all the confidentiality laws that speak to certain circumstances when certain people can share certain information for certain purposes. Child abuse and neglect reporting. Certain situation limits who you can disclose to. Patient authorization is a way for the provider and the patient to write their own personal exception into the law. It can be used to disclose healthcare provider, to disclose SUD program information to another healthcare provider, to a health plan for the purposes of the SUD program getting payment for services it provides. It can be used for SUD program to provide DSS information about a patient's attendance and progress with treatment. It can be used for an SUD program to provide information to a probation officer to establish that the patient is attending treatment sessions. There are many uses of the patient authorization to disclose. And not only 42 CFR Part 2, but the HIPAA privacy rule in the state law permit a provider of services, any of the providers that fall under any of those three laws, to disclose confidential information with the consent of the patient or the patient's legally responsible person. Legally responsible person would be parent for a minor child, guardian for an adult who's been declared incompetent. Okay, so let's talk about patient authorization, and I'm going to give you some examples. First thing to know, that to be valid, the consent must be in writing. So verbal consent, there are some narrow circumstances under the HIPAA privacy rule where verbal consent can apply. There's one very, very narrow circumstance under 122C, I believe, but there's no provision and no circumstance in 42 CFR Part 2 where the patient's authorization to disclose may be given verbally. Okay, now I know some of you have asked about this with respect to telehealth, et cetera, but the consent must be in writing. Not only that, it must contain the elements required for consent that are written in the applicable confidentiality law. Both 42 CFR Part 2 and the state law, and also HIPAA privacy rule, they all they all have provisions that say what kind of information must be in a consent for it to be valid. The authorization must be informed. There are three basic categories of things that must be spoken to in a written authorization to release information for it to be valid, for it to be informed, for the patient to know what's going on. And that is what information will be disclosed, to whom it will be disclosed, and for what purpose. And by the way, the August 2020 rule makes a few changes regarding consent. The August 2020 rule changed to 42 CFR Part 2. And by the way, anytime you have patient authorization, the SUD program their disclosures or the lawful holders disclosures must be consistent with the authorization. And the recipient is bound to the terms of the authorization, can only use the information for the purposes stated in the authorization. Now I'm going to show you a couple of patient authorization forms that I've worked on that combine the required elements of the HIPAA privacy rule, the state confidentiality law governing mental health services, and the federal law governing substance use disorder treatment services. They all have their required elements. They read very similarly, but not exactly the same. And what I'm giving you here, I want to show you that it is possible to write an authorization form that meets the requirements of all three laws in one form. This is for agencies whose information falls under all three laws, or where you have a HIPAA covered entity, a GS 122C covered provider, and an SUD program wanting to share information with each other. This is a form that I worked with people in Cabarrus County to create this form. And this is a form used in a program that treats pregnant opioid users and their children. And it is a form that was created that authorizes the sharing of information among multiple agencies. I'm going to go to another page of the form. You'll see that this form, in my discussions with these agencies, I asked, well, what are you going to use the information for? And there were many things that they wanted to use the information for. This was basically multiple agencies coming together to create a collaborative that where all the relevant agencies could talk to each other about serving, treating, and coordinating care and treatment for a pregnant opioid user, both before and after birth of the child. And I said, you not only need to know who information is going to be shared with and for what purpose, but what information. And some of these laws, including the SUD program law, says you have to be somewhat specific. So there's a balance between having a short, readable, plain English form, but also having enough information there to meet the content requirements of 42 CFR Part 2 and the other laws. There's a balance. This is the balance we struck. Obviously, in this kind of collaborative multi-agency information sharing, not only does the form have to meet the requirements of the law, but you have to be able to have someone that can sit down with the patient, walk through, talk through the form, so that when they sign it, they understand it. Similarly, there is, if you go on the UNC School of Government website, you can find this guide, which addresses information sharing between the juvenile justice system and the behavioral health services system. And this also is a form that provides for multiple parties to share information about the juvenile. There are various sections in this form which are required because of 42 CFR Part 2 and also state mental health law and the Hipaa privacy rule. And because juvenile justice information is also subject to statutory provisions regarding how it may be used and disclosed, we had to account for those laws in this patient authorization form as well. Okay, so those are some examples. It must be informed, which is the purpose of the form. Who's going to share information? What information for what purpose? That goes to the general principle that a valid consent for release of information must be informed. It also must be voluntary. And that's why all three laws that I've been talking about, but including and especially the main one today, 42 CFR Part 2, says that the patient may revoke the consent to release information, the authorization form, may revoke their waiver of confidentiality at any time, except to the extent the program or other lawful holder has already acted in reliance on it. For example, I'm an SUD treatment services provider. The patient signed an authorization form allowing me to release information to their health plan or insurance company so I can get paid for services. Well, if I provide the service and then the patient revokes the authorization that said I can disclose to their health plan for payment purposes, I have acted in reliance on it. I can still disclose information so that I can get paid for the services that were provided. But beyond that, the consent is revoked. There's also an exception to revocation for criminal justice referral consent forms. I'll get to that in a moment. The federal law governing SUD program information says consent must indicate the date, event, or condition upon which consent will expire. If I'm disclosing information by signing an authorization to disclose my SUD treatment information to permit my service provider to disclose information to my probation officer, I might put on the consent that it expires at the end of my probation. Some date, event, or condition which is related to the purpose of the consent. Now, I will tell you that unlike 42 CFR Part 2 and the Hipaa privacy rule, the state law has an automatic one-year expiration due to a specific provision in the state regulations. And it says, except for consents to continue established financial benefits, that, and remember, state law GS 122C applies to mental health services, services for intellectual and developmental disabilities, and substance abuse, says the law. So an SUD program is governed by that state law and for the federal law 42 CFR Part 2. The state law happens to say, you know, our consents automatically expire after 1 year. So even though 42 CFR Part 2 doesn't say that, state law is more restrictive and you have to follow that state law provision. Okay, criminal justice system referrals. And I think there were hardly any people in the room who are from the criminal justice system when we did the poll. So I'm going to go through this rather quickly. Basically, we talked about DSS needing SUD program information to see if a parent, for example, who's in protective services, is attending treatment appointments, is complying, and what their progress is. So you can have an analogous situation in the criminal justice system where a condition of release, for example, is that the criminal offender get treatment. And if the criminal justice system wants to monitor that treatment, then folks in the criminal justice system need the patient's consent, a consent that complies with 42 CFR Part 2. And so in that situation, there is a specific set of requirements for patient authorization. See, I'm looking, excuse me, I'm trying to give it, so. And this is a consent that the patient cannot revoke. And it's for those situations where, for example, a prosecuting attorney is withholding charges pending the individual's treatment, or the court is granting pretrial or post-trial release as long as the person is in treatment, or in a situation where a probation or parole officer is responsible for supervising the patient, who happens as a term of sentence or release be getting treatment. In that situation, there's a specific section of the law that applies to this type of patient authorization to disclose information for these purposes in this circumstance. So as I said, it's irrevocable until a specified ascertainable event. Now, it also says that the person who receives this information in the criminal justice system may redisclose to others within the criminal justice system without further consent. So this is something, if anyone out there needs patient consent in this situation, give me a call or email me and I can talk to you more about this. So while this consent is irrevocable by the patient, the problem is that if you're an SUD program, you're probably also going to be governed by the privacy rule in the state confidentiality law governing substance use disorder services. And both those laws do not permit irrevocable authorizations. So the solution to this, the gymnastics you have to go through, is that you can combine the 42 CFR Part 2 irrevocable authorization form with a court order issued in compliance with Hipaa and 122C. So you're going to need a court order that says you can disclose Hipaa and 122C protected information. You have 42 CFR Part 2 irrevocable consent. And you might think, well, if I got to go get a court order, why use consent? I'll just get the court to order disclosure under all three laws. Well, the problem with that is that the standard for obtaining a court order for information protected by Hipaa and 122C is much less onerous, much lower than the standard for 42 CFR Part 2. So what I'm presenting here as a solution in this situation is most likely the best way to go. Now, I want to get to a few, let me check my time. Okay, I want to get to a few August 2020 changes to the consent requirements. A few years ago, the rules were changed to say, unless you have a treating provider relationship as a recipient of information, the patient cannot authorize disclosure to an agency or entity. So for example, back to the Child Protective Services situation. I'm a parent in protective services. I want to get my kids back. I'm going to go into treatment. I want to show that I can get better and I can handle having my kids back in the home, or I want to make sure they're not removed. So I have an incentive, an interest in disclosing my SUD treatment information to DSS. Well, it used to be I could sign a form saying, permitting disclosure to Orange County Department of Social Services or the Child Protective Services section of Orange County Social Services. But then the rules were changed to say, no, you had to name a specific individual. So I'd have to name a person employed by that agency. Well, that means that person could not share it with others in the agency. And what if that person retired or was on vacation or on medical leave? That was a problem. Okay, so before that change, so when the change was made, you can't name an organization or agency, you have to name a specific individual. I thought that created a problem. Well, fast forward, and apparently SAMHSA realizes it created a problem too. They changed the rule to say that the patient may disclose to an entity of their choosing without naming an individual person within such entity. For example, the Social Security Administration, or for example, Chatham County Department of Social Services. There's also, in the last few years, been some work done around disclosures, patient authorizations to disclose to health information exchanges. The rule now says that you need to name the recipient entity facilitating the exchange. You need to name the HIE and either name all the individuals or participants in the HIE or use a general designation of individuals or entities who have a treating provider relationship with the patient. You could say to XYZ HIZ and any physician, nurse, et cetera, treating me, okay? Now, if a patient's going to use, if your consent form is going to provide for general designations and your patient uses general designations for health information exchange disclosures, you have to have certain information in there. But I'm not going to talk about that other than what I say here on the slide, because state law does not permit a provider of substance use disorder treatment or mental health treatment or services for IDD to use a general designation. State law says you have to use the name of the individual or individuals or a specific agency or agencies. You can't use a general designation as, well, my primary care providers or these general professionals. So you have to name the agency or name the individual. So I think that given this state law, I don't think 42 CFR Part 2 provisions regarding general designations applies in North Carolina. Okay, so I've got 319 and I could say, I'm going to say some things real quickly about subpoenas and court orders. Well, let me ask you, Dee Dee and Alex, I can continue to 3:30 with this presentation, or I can just continue for another 5 minutes and then try to take some questions. What would you like me to do?
This is Mark Didi. I think we have so many questions. I'm not sure where we would start. Maybe if we can just continue on and then we'll regroup afterwards and address all the questions and get those out to folks.
Okay, so we have a way to send answers to everyone?
I think we could attach it to the PowerPoint, which will be available to individuals, my understanding, through Alex. So we can do kind of a Q&A and attach it to the PowerPoint. Does that work, Alex?
Yes,
Yeah.
that'll be perfect.
So for everyone on the program, I am very interested in your questions and answering your questions. I apologize that there's not time to do it on this program, but it sounds like I'm going to be writing a book, right, after this program?
I mean, there may be over 100 questions.
Yeah.
Piece of cake, piece of cake. Okay. All right. So let me continue then. And then for everyone that's asking questions, please know that it's my intent to answer your questions, but it will be in a follow-up document when we release the PowerPoint to everyone that's registered for the program. Okay, subpoenas and court orders. Remember I said, if the information is confidential, you can disclose in response to a provision in the confidentiality law, or with patient authorization, or with court order. So let's talk about subpoenas and court orders. All right. You're a substance use disorder services provider. You get a subpoena. Well, the Hipaa privacy rule permits disclosures in response to a subpoena, but the state law governing behavioral health care information does not, nor does the federal law governing SUD treatment information. 42 CFR Part 2 does not have a provision that permits disclosure in response to a subpoena alone. Remember, the basic rule of confidentiality. If the information is confidential, disclosure is not permitted unless the court orders disclosure, the client consents to disclosure, or the applicable confidentiality law makes an exception to confidentiality that applies to the circumstances at hand. Well, there is no exception to confidentiality for subpoenas in 42 CFR Part 2 or GS 122C. So what does that leave you? That leaves a court order if the person who issued the subpoena really wants the information. Conceivably, if it's the patient's own attorney that's subpoenaing the records, the patient could authorize the release to their own attorney, and then you wouldn't need a court order. But short of that, you need a court order. What do these three confidentiality laws say about court orders? Well, the state law governing behavioral health care information says that a mental health provider must disclose information in response to a court order. The Hipaa privacy rule says a covered entity may disclose information in response to a court order. Neither law expresses any particular procedure, standard, or required findings to guide the court when issuing such an order. Basically, if the information is protected by the Hipaa privacy rule or state law GS 122C, a state court in North Carolina is likely to look at some other source of law for what its standard is. And there happens to be in North Carolina some evidentiary privilege statutes that apply to physicians and psychologists, et cetera. And those statutes say a court may compel disclosure of the privileged information if, in the court's opinion, disclosure is necessary to the proper administration of justice. Well, what does that mean? Well, generally it means, if it's necessary for the truth to be known, for the claims to be litigated in this case, and if the public interest in that outweighs the patient's privacy interests, the court is going to order disclosure. It's a basic balancing test of public interest in seeing that the administration of justice is done and truth be known versus the patient's privacy interests. So that's if you're talking about the HIPAA privacy rule, and if you're talking about state law, GS 122C. That's about as specific as it gets. But if you're talking about 42 CFR Part 2, which we are doing today, then you need to know that there are 4 kinds of court orders spoken about in the regulation, depending on the purpose for disclosure. There is a court order for any purpose other than for criminal investigation or prosecution. There is a kind of court order when someone seeks the information to criminally investigate or prosecute a patient. There's a kind of court order that's needed if law enforcement is investigating or prosecuting a program or person holding the records. And then there's also a court order needed if law enforcement wants to place an undercover agent or informant in a program. I'm going to talk about the first one, may get to the second one. So with all these orders, when a judge is considering, so this is what happens. If someone issues a subpoena for information, you don't ignore it. If your agency or your medical records person or privacy officer is subpoenaed, that you don't want to ignore that subpoena. But what the subpoena is, it's not a court order to disclose. It's a court order essentially to show up at a time and place prepared to disclose. And if it's a mental health or SUD professional showing up at court where testimony is needed, or it's a medical records person showing up with records prepared to hand them over before they're disclosed, before they're handed over in response to a subpoena, those kinds of people have to say, I'm here to comply with the subpoena. However, I cannot disclose this information pursuant to a subpoena alone. I need a court order. So the judge then, the attorneys will argue over whether the information should be disclosed. Given the nature of the case, you leave that to them. The judge may want to know, well, what's in the record? The judge may want to review the records or hear arguments about whether the records should be disclosed. Under 42 CFR Part 2, that process must be in camera, meaning closed from the public. And to order disclosure, the court, in all of those four aforementioned situations or kinds of court orders, the court must find that there's good cause for disclosure. I'll get to that in a moment, what good cause means. And the court must limit the disclosures to the parts of the records that are essential to fulfilling the objective of the order, and must limit it to persons whose need for information forms the basis for the order. So in the non-criminal situation, like in family law cases or child protective services cases, this is the good cause standard. Other ways of obtaining the information are not available. The public interest outweighs the privacy interest. That's the sort of basic standard for the court finding good cause for disclosure. So it's pretty easy to jump over this threshold to meet the standard for disclosing information. When you're disclosing information for criminal purposes, you'll see that there are other findings that must be made that are more difficult to make in a given situation. So basically, this good cause standard when ordering disclosure for non-criminal purposes is weighing the privacy interests, patient's privacy interests against the public's interest in the administration of justice, the truth being known so that the dispute can be resolved. And what the judge is going to look for in the case of public interest is, well, is this information relevant? Does it pertain to a claim or matter or issue in the case? And if it does, is it necessary? Or do we have enough other evidence this would be cumulative? So I have a question here, I think, for the sake of time. We have 1 minute. I will answer it myself. DSS is preparing for a hearing. DSS wants to call Jackie's substance use counselor to testify about Jackie's prognosis. However, Jackie has revoked her consent at this point. DSS subpoenas Jackie's counselor to appear and testify. Can the counselor testify in response to the subpoena alone? The answer is no. Can the court order disclosure? The answer is yes. If so, what findings must the court make? And the answer is A and B. That's the standard. That's the good cause standard for ordering disclosure in non-criminal cases. By the way, I give you a case here where the information was relevant. The court should have said it was not necessary because we have plenty of other information. So that shows you how information can be relevant, but if it's cumulative, the court may not order disclosure. This is a North Carolina case where the court did not order disclosure of information. It shouldn't have used the word relevant. It should have said it's relevant, but not necessary. It's cumulative. And then finally, I will end here and just say that in addition to saying the information would not otherwise be available, in addition to saying, well, the public interest in disclosure outweighs the privacy interest in criminal investigation and prosecution cases, to order disclosure of information, the court would have to find these additional 3 things. So we're at time and I'm going to stop. And I will just say to you that the rest of the slides talk about some other miscellaneous provisions that are August 2020 rule changes. We will get that out to you, and we will also get out answers to your questions.